Hello there, everybody, and welcome to the latest in the series of webinars that we are doing on issues that arise in the First-Tier Property Tribunal. My name's James McHugh. I'm a member of the housing team at Trinity Chambers. I'm joined by my colleague, Brien.
Hello, everyone.
Today's webinar is going to be dealing with improvement notices, which are an enforcement option available to local authorities for dealing with hazards identified under the Housing Health and Safety Rating System. What we'll briefly look to deal with in this session is the following: what improvement notices are, the circumstances in which they can be served, the technical requirements for service under the relevant provisions, the consequences for any breaches, and appealing improvement notices. So to kick things off, Morgan's going to tell us about what improvement notices are.
Thank you, James. Yes, that is the obvious starting point in a talk on improvement notices. Fundamentally, they are designed to deal with hazards in a residential context, and they are used where a local authority is satisfied that there's either a Category 1 or Category 2 hazard exists on any residential premises. The local authority then has the power under sections 11 and 12 of the Housing Act to serve an improvement notice. The notice itself requires that the person served to carry out action that will either remove or reduce the hazard. Again, it's defined in the Act. The definition under the Housing Act is set out there. A hazard means any risk of harm to the health or safety of an actual or potential occupier of a dwelling or HMO which arises from a deficiency in the dwelling or HMO or in any building or land in the vicinity. Something is classed as a hazard regardless of whether the deficiency arises as a result of the construction of any building, an absence of maintenance or repair, or otherwise. And as I've already set out, they are classified as either Category 1 hazards and Category 2 hazards. It's clear, therefore, that it is the effect rather than the cause that is important when defining a hazard. There is further guidance on hazards that can be found within the regulations, but we're not going to cover them in too much detail in this talk. And what is important to note at this stage, it is the category of hazard, and that will determine the level of remedial action required. And I think, James, you're now going to deal with the notices themselves for both Category 1 and Category 2 hazards.
Yeah, that's right. Thanks. So either a Category 1 or a Category 2 hazard can give the local authority the power to issue an improvement notice. What the local authority has to be satisfied first is that, number one, a Category 1 or 2 hazard exists on any of the premises, and number two, that there's no management order already in force on the premises. Once the local authority is satisfied of that, there are a range of enforcement options open to them, and issuing an improvement notice is one of those. They've got to, once an improvement notice is served, then the person who is served with the notice is required to take remedial action in relation to the property. Regardless of whether or not it is a Category 1 or a Category 2 hazard, the improvement notice has to, by the Housing Act, by virtue of the Housing Act 2004, set out the following things. Firstly, it's got to set out whether the notice is served under Section 11 or Section 12 of the Housing Act. Section 11 deals with Category 1 hazards, and Section 12 deals with Category 2 hazards. Secondly, it's got to identify the nature of the hazard and the residential premises on which the hazard exists. Thirdly, it's got to set out the deficiency giving rise to the hazard. Fourthly, it's got to identify the premises where the action is to be taken and the nature of the remedial action that is required. Then it's got to set out the date when the action has to be started by, and it's also got to set out the date when the action should be completed by. The notice must also contain information about the right of appeal under Part 3 of Schedule 1 to the Housing Act 2004 and it's got to set out the relevant statutory period within which an appeal might be made. It's important to also note as a general rule that improvement notices normally become operative at the end of the period of 21 days from where the notice is given, but some improvement notices can provide for the suspension of that period from when they become active until either a specified time in the future or a specified event. In either of those cases, time will not begin to run until the specified either time or event causing the suspension ends. In addition, if there is any appeal against the notice, an improvement notice, that notice will not become active during the appeal of during the period of the appeal process. There are set rules for the service of improvement notices. I think Morgan's going to deal with those now.
Yes, thanks, James. The detailed provisions dealing with service of improvement notices are set out in Schedule 1 of the Housing Act, and they set out essentially who should be served with an improvement notice in various contexts, of which I'll go on to discuss, one of which concerns an HMO. And if you want to learn a little bit more on HMOs and you haven't been binge watching this series already, we would refer you back to an earlier webinar that myself and my colleague Alice Richardson covered on that subject. But focusing today on improvement notices, the first context is where the premises are either a dwelling which is licensed under Part 3 of the Housing Act, or an HMO which is licensed under Part 2 or 3 of the Act. In those two circumstances, essentially licensed residential property, the local authority must serve the notice on the holder of the licence. The next context is where the specified premises are one of the above, either a dwelling or an HMO which is not licensed, and also in this case which are not a flat. In these circumstances, the local housing authority must serve the notice on either the person with control of the dwelling or having control of or managing the HMO. The next circumstance we look at are when the specified premises are a flat. In those circumstances, the local housing authority must serve the notice on a person who is A, the owner of the flat, and B, in the authority's opinion, ought to take the action specified in the notice. This can, of course, include flats which are HMOs. In those circumstances, it would be the person managing the flat. Finally, we look at when the specified premises are common parts of a building containing one or more flats, or any part of such a building which does not consist of residential premises. In those circumstances, the authority must serve the notice on a person who is, firstly, the owner of the specified premises concerned, and secondly, in the authority's opinion, ought to take the action specified in the notice. And finally, as well as serving it on whichever relevant person, the local authority is also required to serve a copy of the notice on every person who, to their knowledge, either has a relevant interest in any specified premises or is an occupier of such premises. And in the instance of someone having a relevant interest, that could include the freeholder, a mortgagee, or the lessee. And James, I think you're going to cover the substantive points of complying with the notice and the consequences of failing to do so.
Yeah, thanks. What we'll try and set out in the next bit is what actions required when somebody is served with an improvement notice, and the enforcement options that are available to local housing authorities against those who fail to comply with an improvement notice. So in terms of what action is required, for the first thing to point out, and I think as we set it out earlier in what needs to be contained in the notice, the starting point is that all improvement notices should set out clearly in them what the remedial action required by the notice is. Now, for category 1 hazards, That will include a minimum requirement that such action will be taken as necessary as to reduce the hazard so that it ceases to be a category 1 hazard, but it doesn't necessarily mean that it would need to stop being a hazard altogether. However, again to note, it is important that the notice can require those being served with it to go further than just the minimum of reducing it down from a category 1 hazard, and can go as far as it likes, including removing the hazard altogether. For a category 2 hazard, it's slightly more straightforward. What is required there is simply to take such action as is specified in the notice. Sections 35 and 36 of the Housing Act 2004 give the Magistrates Court the power to require an owner or occupier to permit action to be taken to comply with an improvement notice. There are 2 significant potential consequences of failing to comply with an improvement notice. The first of those consequences is slightly outside the jurisdiction of the First-Tier Property Tribunal, but worth mentioning nonetheless. Section 30 of the Housing Act 2004 makes non-compliance with an improvement notice a criminal offence, which upon summary conviction, the Magistrates Court could lead to a fine at a maximum of £5,000. The second of the 2 potential consequences is that the local authority can take action themselves to remedy any hazard that's been ignored by somebody served with a improvement notice, and they can recover the costs of remedying that hazard. The power for them to do that is under Schedule 3 of the Housing Act. There are 2 ways in which they can take action themselves. They can either take action with the agreement of the person who has been served with the improvement notice. In that case, the costs of remedying any hazard would be paid by the person who'd been served with the notice. The second course of action under that is that the local authority can take action without the agreement of the person served with the notice, provided that they comply with some additional notice requirements, which we're going to set out now. If a local authority wants to take action without the agreement of the person served with the original improvement notice, they have to serve them with further notice that they are going to do the same. That notice must identify, firstly, the previous improvement notice that is being relied upon, and it's also got to set out the following things in clear terms. It has to set out the premises and the hazard concerned. It has to set out that the local housing authority intends to enter the premises. It has to set out that the local housing authority intends to take particular action in relation to the hazard, and it's got to set out the power under which the local housing authority intends to enter and take action. In addition to that, the local housing authority also has to serve notice on the person against whom the original notice of improvement was served. It's got to serve the notice against any occupier of the premises, and that notice has to be served sufficiently in advance of the time when the authority intends to enter, so as to give recipients of the notice reasonable period and reasonable notice of the intention to enter. The last topic that we're going to touch on is appeals against improvement orders, improvement notices, and Morgan's going to deal with that.
Yes, when it comes to appeals, the first point to note is that there is a right of appeal provided under the Act, and that states that a person on whom a notice is served may appeal to the First-Tier Tribunal against the notice itself. This is a statutory appeal, and one which has been held by the High Court in the case of Brien and Mansfield District Council to be the most appropriate route to deal with disputes The High Court has been quite clear that they do not want to see a glut of judicial review claims concerning improvement notices for obvious reasons. And that decision was affirmed in a case of Wood and Kingston upon Hull City Council, where the First-Tier Tribunal held, or the Upper-Tier Tribunal held, that the test for appeal was not a public law test. Otherwise, of course, it would not be the First-Tier Tribunal who would be listed as the appropriate appellant tribunal in the statute. As for the statutory appeal itself, there are two specific grounds of appeal, and they are set out in Schedule 1 of the Housing Act, along with all details concerning appeals. Importantly, they do not prevent an appeal on other grounds, such as a lack of evidence or a technical point about time issues. But the two specific grounds that are set out in the schedule are clear. Firstly, that someone else should be taking the remedial action and or paying for that action. And secondly, that some other action is the best course of action for dealing with the identified hazard. So an argument often resolving around the cost of the enforcement action that the authority is seeking. And importantly, any appeal must be made within 21 days of service of the improvement notice, albeit the tribunal does have the power to extend the time if there is a good reason for doing so. And as stated earlier on in this talk, the time limit for complying with the notice is suspended during the appeal process. So if a recipient is going to appeal, he does not need to commence any action with complying with that notice until the appeal has been dealt with. And as has been confirmed in Mansfield and other cases, the appeal is by way of a rehearing. The tribunal does have some discretion, however, to take into account matters of which the local authority was unaware when serving the notice on the first occasion. And the powers of the tribunal in dealing with the appeal are that they may confirm, quash, or vary the improvement notice. And that is a fairly brief summary of the appeals process concerning improvement notices.
That covers, I think, all of the relevant issues in relation to improvement notices that we were seeking to do in this brief webinar. What that leaves me to do is thank you for watching. If you have any queries about this topic, about any of the content of the previous webinars, or if you've got any suggestions for future topics, please don't hesitate to get in touch with the contact details provided at the end of this session. I hope you all stay safe during this pandemic, and in the meantime, it's goodbye from me.
And goodbye from me.